Yeah, okay, ready to go.
Wonderful. We apologize for the small technical pause before we start. So we welcome you today and thank you for joining us. I will start by introducing myself. My name is Shahid Hamouri and I'm a lecturer in international law at the University of Kent. I'll be first delivering some welcoming words, and then we will start our discussion. To begin with, this discussion is hosted by Law for Palestine, which is a youth-led nonprofit organization registered in the UK and Sweden. And in order to build a global network of legal professionals passionate about the question of Palestine, provide objective legal content, empower affected communities by enhancing their legal capacity and connecting them with international legal mechanisms, and simulate discussion about Palestine and the Israeli occupation within the realms of international law. With relation to our discussion today, if I may start with the following introductory words. The preamble of the Rome Statute notes that state parties are mindful of past atrocities that deeply shock the consciousness of humanity. State parties recognized that such crimes threaten peace, security, and the well-being of the world. The context of our discussion today generally lies within the occupation of Palestine, a context of grave violations of the peremptory norms of international law, heavily documented by agents of the United Nations and repeatedly condemned for over 50 years. To zoom in, we are speaking specifically about the geographical area of Gaza, the most densely populated area of the world, with 70% population of refugees, 50% population of children who have so far lived over 17 years under siege. Then we zoom in to the temporal context of now, past October 7th. In the past 7 months, the whole of Gaza has been destroyed. No universities or hospitals left. It has become the world capital of amputees and orphans. The city is cluttered with dead bodies, rubble, and mass graves. Those who remain alive are starved. A famine has been declared in the north. Over 15,000 small bodies of children are now under the ground, thousands of prisoners suffering, many killed. As we speak now, Rafah is under heavy bombardment at the risk of invasion. If one were to be an individual who is currently in Gaza now, there's no reaction but hysteria, and there's no reaction but frightened horror. It is difficult for us, who are currently physically outside of Gaza, of this reality, to conceive of this horror. Yet, it is safe to say that the consciousness of humanity, of which we spoke of in the preamble of the Rome Statute, is indeed ablaze. Meanwhile, according to the rules of the global geopolitical status quo, the truth is suspended and questioned. In this case, truth is suspended in the name of efficiency. State representatives continue to undermine the reality, propagating the normalization of atrocity. For international criminal law scholars, this ought not be shocking. Truth has been historically suspended in other atrocities. In such contexts, law yields power as it can contest violence normalized by the status quo. Yet, and however, Palestine has reached out to the International Criminal Court in 2015. An official investigation was opened in 2021. And so far, we still haven't heard anything. In the current onslaught, 5 states have referred the case to the court, with 2 more coming. Questions about the court's impartiality in the choice of cases have been marred by the specter of colonization for years now. They have posed an existential threat to the court's legitimacy, particularly in the eyes of the global South. This case poses a challenge as it doesn't align with the political status quo. Political actors have indeed publicly threatened the court if it were to take action with regards to the case. Yet, arrest warrants are now a determinal element of hope, a determinal element in starting the healing process in the wound to humanity's consciousness. The world looks to the court to ask, will you recognize reality or suspend it? In light of the looming question, we will be joined today by a distinguished panel of speakers who will speak to us of their own experiences in relation to reality and practice and the text of international criminal law. I will introduce each speaker, each will speak for 7 minutes, and then we'll open the ground for some discussion. For the speakers, I will alert you the moment you reach minute 6 by raising up my hand, and then you'll have 1 more minute before you finish your introductory positions. I will introduce, each speaker as they come forward. First, I will give the floor to Ms. Huda Abu Daqqa, a researcher in international law at Law for Palestine, who will speak to us of the reality on the ground and the most recent submission by Law for Palestine to the International Criminal Court. I give the floor to you, Huda.
Thank you, Shahid, for this wonderful introduction. I'm Huda Abu Daqqa, and I will be presenting or talking about our submission, which I'm glad to be doing. So over the past 7 months, we've seen how the situation in Gaza has escalated rapidly, and genocidal action by Israel has become very apparent through statements by Israeli officials, conduct by the Israeli forces, and on the ground, and the policies that have been imposed on Gaza. The atrocities that have unfolded highlight the urgent need for international legal action, especially with the ICJ's finding that there is, in fact, plausible evidence that Israel is committing a genocide in Gaza. Building on the ICJ's findings, we at Law for Palestine submitted a joint communication to the Office of the Prosecutor of the International Criminal Court regarding the perpetration of the crime of genocide by members of the Israeli War Cabinet. The communication consists of a 250-page document to the ICC, drafted by 30 lawyers and reviewed by over 15 experts. Through the submission, we urged the ICC to take immediate action in addressing the ongoing genocide. This communication is the first of a series of communications we will be submitting to the ICC, this one focuses primarily on intent. It provides a compelling case for the genocidal intent by Israeli leaders against the Palestinians and the ICC's prosecutorial policy of what it followed in other cases. The unfolding genocide in Gaza is actually the inevitable outcome of years and years of Israeli policies that targeted Palestinians as a whole, regardless of where they are. And October 2023 marked the start of a new era where Palestinians in Gaza are being subjected to genocidal policies and have been subjected for a continuous period of 7 months. This submission, or our submission, meticulously outlines the genocidal intent harbored by Israeli leadership against the Palestinian people. The evidence we provided included public statements by Israeli officials, including the Prime Minister Benjamin Netanyahu, President Isaac Herzog, as well as members of the Knesset and the cabinet. It also goes beyond these statements and links Israeli policies across Palestine and particularly in Gaza to show Israel's overall intent to commit genocide. It also provides an array of evidence showing targeted actions against medical facilities, agricultural lands, and water systems, all aimed at crippling the Palestinian society in Gaza. Additionally, our submission draws parallel to historical genocides like those in Yugoslavia and Rwanda, where similar patterns of ethnic cleansing, for example, were legally recognized as genocide. We highlight Israel's systematic policies that can be seen as genocidal techniques, such as the alleged use of human shields and the destruction of Palestinian cultural heritage, which are actions that further demonstrate a clear intent to eliminate a people. Despite the overwhelming evidence and the historical precedents set by the ICC itself in cases like Darfur, where it issued an arrest warrant based only on reasonable grounds to believe that there is genocidal intent, the ICC remains hesitant in the face of the Israeli case, as usual. This hesitance is alarming, especially considering the ICC's proactive response more recently to the situation in Ukraine, where it quickly mobilized a large investigative team and issued arrest warrants and several arrest warrants, actually. Therefore, we urge the ICC to take similar action immediately to address the urgency of the matter, especially with the alarming death toll that has reached almost 36,000 in a span of 7 months, around 40% of which are children, a toll that will continue to increase if no immediate action is taken. The ongoing siege and violence in Gaza have also been documented and criticized heavily for decades, with various UN bodies and international experts recognizing the severe implications of these actions, the ideological underpinnings of these policies, the ideological underpinnings of these policies, rooted in a settler colonial mentality aimed at the displacement or eradication of Palestinians, are also evident and have been greatly promoted by both by Israeli leadership, and have actually indirectly given them the power to go forward with the genocide. It was basically setting the floor for it. Because they faced no consequence for their actions over the years, actions that have continuously and gravely breached international law. As the ICC continues to delay taking action, its legitimacy and relevance as an international judicial body is increasingly at risk. The situation in Gaza, part of broader geopolitical and human rights issues, cannot be ignored without serious implications for the international legal order that was established post-World War II. It is very imperative for the ICC to step up, acknowledge the evidence of the genocide, and proceed immediately with the necessary legal actions to uphold international justice and human rights. Failure to do so not only jeopardizes the court's standing, but also signals a dire erosion of global trust in the mechanisms meant to protect the most vulnerable from the most heinous crimes, and essentially leaving the people of Gaza to face the genocide on their own, as what's happening right now. We've seen the genocide happen across of Gaza, and city after city within Gaza undergo heavy military action and ground invasions, etc. Most recently, Rafah, which no one expected to happen in such a grave manner, or we hoped it wouldn't happen. So yeah, this is all from me. I look forward to hearing any questions and answering them moving forward. Thank you.
Thank you so much, Huda, for putting us within the context and within the also what has so far been submitted to the court, and the overwhelming level of evidence that has been submitted to the court so far. And thank you for your really hard work on this. I now would like to welcome Dr. Tristino Marellino. I'm very sorry, my dyslexia played very well here, who's a member of the legal team representing the Gaza victims before the ICC and a professor of law at the Liverpool John Morris University. He will delve into the expectations of the Gaza victims at the International Criminal Court, while reaffirming the court's crucial role in upholding international justice and law in Palestine, despite current external pressures. The floor is all yours. You are muted.
I had done it, but maybe I was not authorized before. Now I got the authorization. First of all, many thanks for having me today, and many thanks to Law for Palestine for organizing this very, very timely event. I will start by looking briefly at the pressures of the International Criminal Court at the moment, and then to move to the potential likely outcome from this following these pressures. In doing this, of course, I will describe one of the scenarios which also reflects the expectations of Palestinian victims in this situation. So, very briefly, in these last 2 weeks, we have assisted, particularly thanks to Israeli media, that have spread rumors that the International Criminal Court is going to issue arrest warrants against Israeli officials in relation to the Gaza war. The purpose of the dissemination of these so far unfound in the news seems very clear, pushing Israel's allies to prevent the court from issuing any arrest warrants. And indeed, Israel and the US are trying to shift the decision facing the ICC and the prosecutor to be taken on political rather than legal grounds. US President Biden, for instance, has promptly stressed that the ICC has no jurisdiction to charge Israeli officials. 12, as everyone knows now, US senators have threatened the prosecutor, Karim Khan, that there will be repercussions if the court issued arrest warrants against Israeli officials. Threats to the court have been so serious that the prosecutor has emphasized that attempts to influence the court constitutes an offense against administration of justice held under the Rome Statute. How the court is going to react to these political pressures will be crucial not only for the victims in this situation, but also for the legitimacy and credibility of this institution, or even for the same existence of the International Criminal Court that, just to remind everyone, so far has failed to hold anyone accountable in the Palestine situation, which is one of the most documented contexts for the alleged commission of international crimes. The prosecutor has recently stated that the investigation is proceeding with the utmost urgency. So I think the question now at this critical juncture when the international community is facing a plausible genocide in the Gaza Strip, the question is not whether, but how the court is going to approach the investigation into the Israeli-Palestinian setting. For a matter of time, I envisage two different scenarios. In the first one, the court is going to withstand political pressures. In practical terms, this means that the prosecutor will go where the facts lead him and prioritize the cases on the basis of his office established practice. So the assessment of evidence will be conducted in line with standards of proof set out in the Rome Statute. The prosecutor's selection of cases will take place on the basis of the gravity of the alleged crimes, the degree of responsibility of the suspects, and potential charges. What does this mean in practical terms? In practical terms, this means that the arrest warrants will concern individuals in senior leadership positions who bear the greatest responsibility for alleged international crimes widely documented in this situation and in Gaza in particular. With respect to the Strip, without any intent to be exhaustive, I refer in particular to Israel's intentional attacks against civilian and civilian objects, extensive destruction and appropriation of property not justified by military necessity, starvation as a war crime, but also to the forced displacement of almost 2 million people as a crime against humanity in a context when there is no safe place, with the serious and ever-growing risk of being deported from the Strip, so from the Palestinian territory to Egypt. Let's just focus on crimes against humanity. I believe that an independent and impartial prioritization of cases cannot ignore the context in which these hostilities are taking place. And it's important to stress that the current war on Gaza comes on top of almost 17 years of blockade, which is imposed by Israel. And this context, widely condemned by the international organization, including the UN Secretary General, may amount to a widespread and systematic attack against civilians. In international criminal law terms, this means crimes against humanity. At the same time, victims would also expect, following the decisions of the International Court of Justice, that the selection of cases would concern the plausible commission of genocide, as discussed few hundred meters from the International Criminal Court. So while a decision to issue arrest warrants against Israeli leaders might have political and a political impact on the court, these short-term effects are far, I think, outweighed by the severity of the medium and long-term positive consequences for the court standing. I think we can come back to this, but the independent and impartial prioritization of cases would enable the prosecutor of the International Criminal Court to reverse the court law credibility ratings. The Palestine situation is a reminder of the court's role in ensuring equal access to justice for all victims without any discrimination, which is extremely important given that Palestinians are already subject to institutionalized discrimination. And equality and non-discrimination, as well as minimum standards of fairness, are key to upholding the integrity of the prosecutor mandate. In the second scenario, and I will conclude with that, The second scenario would constitute a form of surrender to the political pressures, in particular of the US. The court will privilege its cordial relationship with the United States over the fulfillment of its mandate. In doing so, it would strongly impact its image as an independent and impartial institution. In practical terms, this surrender, I think, would be reflected in one-sided investigation, which means investigation only concerning members of Palestinian armed groups, but also an investigation with a very narrow scope, which means encompassing, for instance, only crimes allegedly committed by violent settlers in the West Bank or by so-called small fishes in the Gaza Strip, for instance, disproportionate attacks against civilians. Carrying on with such double standards in a context of an unfolding genocide, I think would mean for the court failing the final test bench for the credibility of the institution, and would also confirm, as was said before, the reasons underpinning the growing disillusionment in international criminal justice project in the global south among states, victims, affected communities, and civil society organizations. Thank you very much for your time.
Thank you. And these are, of course, a lot of things that we need to unpack in everything that you just said, which is of the utter importance at the moment, because as we stand now, perhaps short-term political decisions or short-sighted political decisions might threaten the legitimacy of the discipline as a whole going forward, especially as you noted from the Global South's perspective. Now, I would like to give the floor to Abdelghani Sayed, who's a former worker at the ICC Office of the Prosecutor and a PhD researcher at the University of Kent. He'll be talking to us about the prioritization of investigations committed in Gaza, building on prior cases and the policy of the court in relation to case prioritization, including genocide, aligning with the current policy. Abdelghani, you have the floor.
Thank you, Shahd. And I think what I wanted to talk about would follow perfectly from what Cristiano was just talking about. And I wanted to talk about the bad news in the news about potential arrest warrants. Why potential arrest warrants rumors may actually be very bad news. So I really want to follow from the last point Cristiano mentioned, which is that potentially the Office of the Prosecutor will try to prioritize cases against members of Palestinian armed groups, and why, in fact, this is definitely something that goes against the policy and practice, the announced policy and the previous practice of the Office of the Prosecutor for the last 20 years. So since the office started operating about 20 years ago, or a little bit more, it has been very keen on ensuring that its operation is governed by standards, and it is coherent, it is transparent, and it is predictable, ensuring that the performance of the office is predictable. So whenever the office chooses specific situations and chooses to investigate specific cases within these situations, the office wanted us to believe that this performance is coherent and is predictable, etc. The reality is, and I'm not going to address this part, but hopefully maybe in the Q&A, the reality is there is nothing constant in the policy and in the performance, in the practice of the Office of Prosecutor, except one thing, which is straightforward biases, deeply rooted, and these biases are not only political but also cultural, actually, and hopefully you will have time to discuss that later. And this bias is against non-state actors and is against actors perceived to be illiberal or uncivilized. And this is why I read rumors about potential arrest warrant as a bad news, because this office is biased against this kind of actors. And this is why I think it will actually not try to prosecute Israeli officials, or it will do its both sides. Like it will try to prosecute both sides. So I wanted to say that according to the policy and practice of the Office of Prosecutor, the Office of Prosecutor has to prioritize the situation in Gaza, 2023, 2024, and then within that situation, and within the situation in Palestine, it has to prioritize cases against Israeli officials. This is my argument. So the Office of the Prosecutor, since it started as early as in 2003, has been keen on issuing policy documents, ensuring that it will be selecting situations according to standards. So the idea is that there are crimes that are happening in the world. Many of them fall under the jurisdiction of the court, but the Office of the Prosecutor will only prosecute the most serious crimes. And this is a comparative criterion. So the idea is that country A and country B fall under the jurisdiction of the office, but the office will only investigate situation A because it is more grave than situation B. This has been the policy documents and the practice also of the office since the beginning. And this is why, for instance, in 2006, Prosecutor Moreno Ocampo made sure to clarify to the people that he will not investigate the situation in Iraq against British administrators of a detention facility, because victims in the communications the office received were about 10 victims of torture. So the prosecutor indicated that the number of the victims was very minimal, and accordingly it would not investigate it, and that the office was very busy with other crimes, other situations, that involve so many victims. In Africa, he mentioned Uganda and the Congo, I remember that moment. Numbers were the most important thing at that point. And then later, bit by bit, the office started talking about, in practice actually, first, started talking about some, instead of talking about quantitative standards, started talking about qualitative considerations. So the idea that it's not only the number of the victims, but also the nature of the crimes and the manner of the commission and how outrageous and appalling these crimes were. It even developed a standard that was very ridiculous at the moment in 2006, which is social alarm. So that crimes have caused social alarm in the world. Of course, a very racist standard, because Charlie Hebdo has created much social alarm than many way more appalling crimes in Africa and in Asia and in the Arab world, in Latin America, etc. So there is now the idea of quantitative and qualitative standards. We have the number of the victims, and we have other qualitative standards, such as what? Such as the nature of the crime. For example, the office will prioritize cases against children, cases against women involving sexual violence, for instance. Cases, for example, such as involving summary executions. As Tristino mentioned, also crimes against humanity, genocide, these are very grave crimes, whereas war crimes may be grave, but not necessarily. Very minor acts can constitute war crimes. So nature of the crimes. There is also the scale of the crimes, how widespread and the commission of the crimes has taken place. And there's also the impact of the crimes. So for instance, in the Haskanita case in Sudan, the number of the victims was very limited, less than 10 peacekeepers, but the office considered it a very grave case and decided to prosecute it because the office claimed there was a lot of indirect victims to a crime against peacekeeping forces, because now the lack of safety and peace may be the result. So the idea of the impact on the indirect crime, that's what the office said. Around the same time, by the way, the office refused to investigate a crime, the situation in the Gaza aid flotilla in 2009 or 2010, I can't remember, because the number of the victims was limited, but also the office decided that maybe the Israeli officials did not intend to kill the international activists at that point. Whereas in Sudan, this was a premeditated attack and it caused a huge impact, etc. So there's the idea of qualitative and quantitative considerations. The Office of the Prosecutor deprioritized, committed to its bias against non-state actors and against uncivilized, illiberal actors. The Office of the Prosecutor deprioritized the potential cases against American forces in Afghanistan and decided to prosecute only Taliban. Again, because the crimes of the Taliban were considered more grave in the sense that they involved more grave crimes in terms of their nature, manner of commission, etc., etc. And the office considered that all the crimes of the US in Afghanistan were not that grave because the US, never intends to kill people. There's this idea. So even if it kills so many people, the US doesn't intend. They are always either part of a collateral damage, as people say in media, or Afghan armed groups used human shields, etc. So the idea that the US didn't intend. So this is how the Office of Prosecutor deprioritized cases. We should conclude in a second. This is how the Office of Prosecutor deprioritized cases against the US. And then there's a very important standard that we have in the 2016 policy paper by the office, which is basically whether the members of the group, so we have two groups here, we have the Palestinians and the Israelis, members of the group form the object of another ongoing investigation or prosecution in an international crime. On my view, in terms of nature of the crimes, impact of the crimes, manner of commission, scale of the crimes committed in 2023 to 2024 are way more grave than any other thing that Palestinians committed and that the Israelis have committed also, that the office had investigated in the past. The last important standard is that Prime Minister Netanyahu has been has formed the object of investigations for 10 years for very grave military operations, 2024 and 14, with a big number of victims, and the Great March of Return 2018, and the settlement activity. Accordingly, I'm of the view that if the office wants to stick to its extremely incoherent practice and policy, it will have to prioritize Palestine and make a case very soon, and it will have to be against Israeli officials. The issue is, I really think it will not. And it will either try to be balanced or worse, even worst case scenarios, as Tristino mentioned. It could actually seek to prosecute Palestinian leaders and then Israeli settlers, very tiny organizations. Yeah.
Thank you so much for that, Abdelghani. And indeed, the vagueness of which you speak has a very odd pattern that fits very well with Global South's critiques of the court. That vagueness seems to justify itself in weird ways of indeterminacy. So last, we are moving towards Mark Kristen, who's a professor of international criminal justice at the University of Fraser Valley. And we are ending with Mark because hopefully you'll be able to talk to us about what happens if we get the arrest warrants, and answering all of our questions in relation to the potential procedures and scenarios for issuing them, their implications, and the responsibilities of the 124 ICC member states in response. Kristen, you have the floor.
Hi, thank you very much. Thanks for having me. Thanks to all of the other panelists. It's a pleasure for me to be here and to listen to you. So obviously, and this isn't surprising, this happens in every ICC situation, but perhaps the scale of this is more significant, is there's a lot of, I think, confusion and Justino spoke to this, confusion, but also fed by rumors and misinformation and threats. And there's kind of it's hard to kind of make reasonable points sometimes. And in these contexts, expectations around what the ICC will do or can't do become driven by less, unfortunately, by facts, and in many instances than by reactions to reactions. And we're seeing this very much, that we're in an extremely reactive space. And I think it's important to take a step back and think about, especially given what has already been said, what the ICC does and doesn't do, and the fact that it's absolutely inconsistent. The only thing consistent about the ICC is its inconsistencies over time. And that's the nature of the institution you're working with. It is transparently inconsistent, right? So, and I think that's important, and to kind of accept on some level that you should be expecting some inconsistencies, that the ICC is not capable, willing, resource to address the full fulcrum of atrocity crimes committed dating back 5, 6, 7 years. It's not even going to be able to address the atrocities, all of the atrocities that have happened since October 7th or yesterday. It's just not in a position to be able to do that. And so when we're thinking about whether the ICC will fail or succeed, the truth is all situations before the ICC show that the ICC just happens to both fail and succeed, sometimes at the exact same moment, right? It'll fail some people and it'll achieve what some people hope. And I think it's important, again, to look through some of that information, and misinformation, I should say, and I'll try in my remarks to kind of focus on a few of those things. The most important is that the ICC is not, this whole situation is not about being against Israel, but the ICC should be acting on behalf of victims and survivors. That's the point. Israel would prefer this to be framed as being the ICC against Israel, but I think we need to push back on this framing to say it's not against Israel, but for the victims and survivors of atrocity crimes in this situation. When it comes to prioritization, and I was keen to listen to the comments that have been made, my assumption is actually the prioritization will be led by the prioritization of certain crimes that can be investigated and arrest warrants issued when the ICC does not have access to the actual crime scene. War crimes can become very difficult to ascertain, at least, with the principles of international humanitarian law, unless you have access to evidence, which the ICC doesn't. So I agree with those who have made the point that things like starvation and the denial of aid are policy-oriented atrocities that are pretty. You don't really need to go to Gaza. You don't need investigators on the ground to see that is a crime that is being committed against the people of Palestine. On the other side, with respect to Hamas, the hostage taking does not require further investigation. It is a crime under the Rome Statute. Now, there is still this question, the rumors, right? Will these arrest warrants come or not? I think it's very difficult to say, and it depends. I mean, the best evidence that we have that it will come is basically assuming that Israel's hysterical response to the idea of arrest warrants wouldn't happen unless they were coming. That's the best kind of reasoning, right? That they wouldn't react so sharply if there was nothing to it. And why would they know? Well, whether it's directly or indirectly, Israel has a terrifically sophisticated intelligence network, and the ICC is not immune to spies and intelligence operations. So they will know that arrest warrants are coming before arrest warrants are coming. And we should just accept that, whether it's their own spies or intelligence operatives at the ICC, or it's American or some others that are sharing this information, they will have that information before it arises. Now, in terms of procedure, what is less clear is if indeed these arrest warrants are coming, at what stage are they right now? So one possibility is that Karim Khan is going to apply for these arrest warrants, right? He has to apply to the judges to issue the arrest warrants. It's a common misunderstanding that the prosecutor issues arrest warrants at the ICC. In fact, the judges at the ICC in the pretrial chamber issue arrest warrants, and the prosecutor has to apply for those. If he has already applied for them, then the decision ultimately rests with 3 judges as to whether to issue these arrest warrants. And this matters in part because you see a lot of pressure on Mr. Khan, but if the prosecutor has already requested arrest warrants to be issued from the judges, then it's actually not up to him anymore. The train has left the station. It's up to these 3 judges, and they will be attacked with threats from the United States and others. But it's not clear yet, at least to me, whether or not there has been an application of arrest warrants or not, and that'll have an effect on timing as well. Another procedural issue is whether or not the ICC prosecutor will ask for the arrest warrants to be issued publicly, so it'll immediately become public knowledge that the arrest warrants have been issued, or under seal, so basically confidential arrest warrants. The reasoning for confidential arrest warrants is that then if a person who is targeted with a warrant travels to a country that has obligations under the ICC, they can immediately be arrested because the warrant will be unsealed and they'll have the obligation. It'll be kind of a surprise element to it. And there are a number of sealed arrest warrants that have been issued in the past. I don't think this is just my personal view. I don't think, especially for someone like Gallant or Netanyahu, that there will be a sealed arrest warrant. Why? Because there's also past precedent that for particularly senior government officials, the ICC publicly issues those warrants. So it had a conversation in relation to Sudanese President Omar al-Bashir, who was wanted for genocide, war crimes, and crimes against humanity, whether to issue a sealed arrest warrant. It decided no. He was the president at the time. It publicly issued the warrant. For Vladimir Putin, also a public arrest warrant. For Libya's Muammar Gaddafi, also a public arrest warrant. So it remains to be seen, but my guess is that when the warrants are issued, they will be publicly issued and known. So what consequences arise? I'll just make a couple of points because I think I've already spoken for a few minutes, 5 minutes or so already. One thing that I wanted to point out, because again, this is misinformation or disinformation, whatever we want to call it, is the argument from certain Israeli sources that, hey, we have a very robust democratic judicial system, and therefore the ICC can't investigate and prosecute international crimes that have allegedly been perpetrated by our government officials. This is not true, and it is not how complementarity, the principle that binds the ICC, works. Israel, if its leaders are targeted with warrants, can challenge the admissibility of cases before the ICC, but only if that judicial system is investigating the same people as the ICC for the same conduct. So if the ICC issues an arrest warrant for Netanyahu over the denial of aid and the starvation of people in Gaza, Israel can challenge the admissibility of that case, but only if it genuinely investigates Prime Minister Netanyahu for the starvation of civilians and the denial of aid. It doesn't, you can have the most robust and remarkable and shiny Ferrari-style justice system in the world, but it doesn't matter if it's inactive. If it is inactive on these issues, then you can't challenge the complementarity of the ICC. And of course, what we've seen repeatedly, whether it's 2014, 2008, 2021, or 2023 to now, is the Israeli justice system has been consistently reluctant to hold its own perpetrators, alleged perpetrators, to account for international crimes. And the other thing that I think will flow here is that if these arrest warrants are issued, there's the question of what does this matter? What will happen next? Again, going back to expectations, and this will be my last point, going back to expectations, we should not expect from practice and from history that the warrants will be enforced. that even if the ICC issues an arrest warrant tomorrow for Benjamin Netanyahu, that the next day he will end up in The Hague. That is very unlikely to happen. And indeed, when the warrants are enforced, it'll probably take us all by surprise. The only thing that seems common about when warrants are enforced is that they surprise everybody, including close observers. It is important to note that all 124 member states of the ICC will be obligated to enforce that arrest warrant if Benjamin Netanyahu or whoever's targeted with a warrant travels to their states. They will be obligated to the ICC to enforce that warrant and surrender that person to the court. Non-member states like the United States, India, China, Russia will not be under that obligation. So the question then is, so what? Does this even matter? I believe that it does. Douglas Guilfoyle has said, for example, that it will make it harder for states like the country I am in, Canada, to sell military weapons to a country governed by people who are wanted by the ICC. It will be easier for someone like myself talking to the government to say, how dare you do this when these people are wanted by the same court that you support, right? That's one thing. Two, and I think this is the most important thing, is justice isn't always about outcomes. It isn't always about enforced arrest warrants. It really matters, and it's about time, it's late, but it's about time for the ICC to simply say, again, not to Israel, not to any particular states, but the victims and survivors, we believe you. We believe that this is what happened to you, and we believe that this is an international crime. And even if those arrest warrants aren't enforced, there is justice in the pursuit of justice, in the process of pursuing justice and believing victims and survivors. And I sincerely hope that happens and look forward to our conversation about the consequences of what that might look like. Thank you very much.
Thank you for that, Mark. Really appreciate it, and it's quite alarming to see that nothing has happened, and of course the whole world is now stepping on their toe as our discipline becomes the light of the day, let's say. So we have a lot of questions in the Q&A. I've tried to start to summarize some of them, but we have a few moments to discuss. I've given you some of the time that was allocated to the moderator's questions, but I was interested to hear more from Tristino on what do you think would be the long-term effects, because you talked generally about if the court looks at the short-term effect, like if the short-term effects in terms of the political pressure on it, and what would be the long-term effects if the court yields to those political pressures that it's currently seeing?
Well, of course, this answer would require much longer time than what we have. But in 2017, I wrote an article with the colleague Valentina Zarova. The title of this article was "Why the ICC Needs Palestine More Than Palestine Needs the ICC." I still believe that this title, this statement is true today, because, as I said before, this medium and long-term positive effect for the ICC, are reflected, first of all, in the possibility to regain, credibility and legitimacy, for an institution that so far has failed to hold anyone accountable, not only in Palestine, but also in Iraq and Afghanistan. And so I refer to the disillusionment that now the court has, particularly in the Global South. So this effect, first of all, will be to get legitimacy and credibility for an institution that at the moment has very poor credibility and legitimacy ratings. And we, I think, are already seeing some of these positive effects, particularly in the area. Just let's not forget that in the area, when I'm talking Middle East, the court has never been seen very positively by states. We have very few, in contrast to Europe or to Africa, for instance, very few states have ratified the Rome Statute. As soon as the investigation has become effective, as soon as there have been rumors around possible arrest warrants, Lebanon has announced that it's going to accept the jurisdiction of the International Criminal Court. So I think that one of the medium and long-term effects will be legitimacy, in particular among Arab states that so far have been very reluctant towards the International Criminal Courts. So these effects will be among the states, but more generally, as I said before, in the global south. These are just some examples that I think would increase in case the court would put in place effective, independent, and impartial investigation.
Thank you so much for that, Justino. I'm quite amazed also by your capacity to keep time. Abdel Ghani, so one of the questions in the chat is referring to the fact that the absence of this policy of prioritization or its clarity perhaps renders, again, as Justino has told us, of the fear of the global south, renders a lot of the court's positionality questioned. This leads me to the question, so given your experience, how would you describe the biases at the Office of the Prosecutor in relation to Palestine, if we are to imagine them broadly? How would that shape the perception of the case at the moment? If you can speak to that briefly.
I would say that rather than thinking of how the office has been dealing with Palestine and how Prosecutor Karim Khan spoke at the Rafah border or in Cairo, and the statements he issued since the end of October 2023, rather than thinking of this as an aberration, as something weird, and even in Afghanistan, in the 2021 deprioritization of the US, of the crimes of the international forces, rather than thinking about this as an aberration, as an exception, as something that goes against the standards of the Office of Prosecutor or the standards set by the Rome Statute, I think it's much better to think about this in the logic of that Anthony Anghie suggests in his book Imperialism and the History of International Law, something like colonialism. Yeah, I can't remember. Anyway, but the idea that basically that rather than thinking that it was an exception, actually the practice of the Office of the Prosecutor over the last 20 years and the policy papers it has issued, in its endeavors to avoid prosecuting liberal state actors and its endeavors to commit to its biases against non-state actors and perceived uncivilized actors, it's this endeavor of the Office of Prosecutor that has constituted its policy. So what we know today as the policy of the prioritization is the result of what? It's the result of the Office of Prosecutor trying not to prosecute the British in Iraq, trying not to prosecute the Israelis in the Gaza aid flotilla, trying to prosecute non-state actors in Sudan in the Haskanita, trying not to prosecute the US in Afghanistan, trying not to prosecute the Ugandan government and to limit its investigation to the Lord Resistance Army crimes. At that point, Moreno Ocampo said it's because of numbers, because Lord Resistance Army committed massive crimes and the government did not commit such big crimes, and accordingly we will limit our investigation, our prosecution to the Lord Resistance Army, and we will get back, this is 2006 I think, or 7, I can't remember, we will get back to the government forces crimes later. Now we are in 2024. Of course nothing will happen with the government of Uganda. So the bias is deeply rooted. It's not really against Palestine per se. It's actually constitutive of the standards of the Office of Prosecutor. At the moment, of course, as Mark mentioned, there would be a big problem, and this is related to the biases against Palestine, in, for example, addressing issues related to conduct of hostilities, Israeli conduct of hostilities, whether under war crimes or actually, as Cristino mentioned, crimes against humanity or genocide. There will be a huge problem, and this is essentially because of the biases against Palestinians. Because of these biases, the Office of Prosecutor is ready to interpret the entirety of Gaza as a big human shield. this is because of straightforward cultural and political biases. And for instance, as Mark mentioned, the crime of hostage taking by Palestinians is very easy to conclude, to make a conclusion about without further investigation, without any need for evidence. But somehow, the crime of hostage taking and of use of Palestinians as human shields and the crimes of rape, etc., by the Israelis, we don't even think about them. Some of the Palestinians in Gaza and in the West Bank were straightforward hostages. Straightforward, like in the first couple of days in the West Bank, a Hamas leader was taken and was killed for no reason. He was a Hamas political leader, spokesperson. Like he's really not part of the hostilities, and he's in the West Bank, and he was taken hostage, straightforward hostage. Many of the Gaza citizens, we have seen them, we have seen the images. These were hostages, but we don't even think about that. And also, Prosecutor, of course, has the same cultural and political biases that trust Israel, that the Palestinian hostage is a detainee because Israel has a state and they can write police reports, etc., etc. So this is the bias on Palestine. Otherwise, the bias is not in Palestine, I think. It's really a global South issue. It's much bigger than Palestine.
I absolutely agree a lot. And a good part of the literature that exists now is about the epistemic bias, in the sense that if you look at who are the people working in the office of the prosecutor, you would find a very specific background of people whose experience, lived experience, tends to be not directly, hasn't been directly under the risk of bombardment from the global north, and most of armed conflict in contemporary armed conflict happens in the global south. So when you exclude people who haven't had any affiliation whatsoever with the context of understanding what domination and war look like, you're very much in a place where you can limit conceptualization of war. So I'm going to link two questions together, because Karim Inara is asking us about the cases of the link between the ICC deprioritizing and the availability of evidence. And Mark, I'd be very interested to hear, because you seem to say that what we have evidence for, of course, and I'm not sure if there are rules about this. Of course, the primary reason why we're incapable of going into Gaza is because of Israel. And one of the primary points put forth by the International Court of Justice has been the preservation of evidence. And historically, we have enough evidence to say that Israel has a policy of a destruction of evidence. But aside from that, why can we not say that the death of 34,000 people in a densely, like, there is the extrapolation of evidence without looking at the actual bodies, through just the fact of how much weapons were used, densely populated area. So we can all deduce, like it takes a very simple a deduction thing. So I'm wondering how it works in relation to, at this stage, assessing the evidence, and how could that be in the rationality of the court?
Yeah, thanks so much. And just to flag that, unfortunately, I have to leave in about 10, 12 minutes or so. Sorry, I'm really sorry about that. But thank you for the question. And actually, before I answer that, because I think it is important, I just wanted to return to something that Abelani and Triestino had talked about, and it's this question of bias. And again, I'm really interested in tracking misinformation and disinformation about the ICC, right? And I think one of the amazing things is you have Israeli propagandists and supporters and their allies saying the ICC is targeting and biased against Israel, right? And this is actually quite a remarkable thing to say when, over the Mavi Marmara, the ICC declined to investigate and prosecute, right? It's literally if there is any bias, it would literally be quite the opposite, right? But again, we create these battlegrounds over who's being biased against, and in that battle, somewhat very reactionary battleground, on spaces like Twitter or in op-eds or whatever, the truth doesn't really come out, which is that, there may be structural issues and biases at the ICC. I'm someone who believes that's, the ICC isn't immune to systemic or structural racism, etc. But the truth is that, it has declined repeatedly and been very, in some ways, slow to address atrocities committed in the Palestinian situation. And then why that is a separate conversation that others are better suited at talking about. And then a second point that I just wanted to say about the Global South is I agree. And I've been tracking and researching for the ICC for longer than is probably healthy. I should probably go do something else at some point. And maybe I will. But Global South states have always said, look, you're biased against us because you're not investigating the situation in Palestine. You have a situation now where whether or not the arrest warrants are coming, and I do think they are coming, but whether or not they are coming, this is the chance for those states to stand up and say, this is exactly why we wanted to join the ICC in the first place, because we believe that eventually it would stand up to powerful states. We believe that it would transcend global politics and speak truth to power. We believe that it would investigate without fear or favor. That's why we joined the ICC. So now we're going to stand up and actively support it. But I have not seen very much of that at all. In fact, the state that's been most strong in support of the ICC in the last few days, since all of these rumors and attacks have come out, is Belgium, a state that has a terrible history in the Global South that is obviously for another time, right? So very interesting, and it would be good to have these states kind of speak up a little bit more from the Global South. It's a very good question on evidence, and I think it would require a whole second panel. So I won't go too much into it, but I think what you see at the ICC is an attempt to address low-hanging fruit from an investigation standpoint, and then consequently try to build cases. And sometimes they do that, and sometimes they don't. But you can imagine, if you look at the Ukraine situation, that the ICC issued arrest warrants for Vladimir Putin over the transfer of children from Ukraine to territories held by Russia or Russia itself. That is a very serious crime, but it was also a crime that Vladimir Putin effectively admitted to, right? It did not require additional resources. So those resources could be spent to building other types of cases. And maybe eventually the ICC issues additional arrest warrants, which is not without precedent. Omar al-Bashir was first investigated for war crimes and crimes against humanity, and then the genocide charges were laid against him 2 years later. So what I think we're seeing with the ICC is a strategy that would look at that, would look at trying to do something more quickly, the low-hanging fruit, and then continue to build additional cases. I just want to mention two things that I think are important as evidentiary sources. One, the ICC is speaking, and this is very good, is speaking to medics and doctors who have been working in Gaza, as well as humanitarian aid officials, because there they can gather the evidence as quickly as possible about what actually happened with a bomb attack, etc. And the second, which I think is really important, is obviously so many of these atrocities in Gaza have been recorded on video. This is a well-documented crime scene. So it may be possible, but it would require a lot of work, and it would be largely unprecedented for the ICC to add additional charges that were based on open source information. Again, whether or not that happens is, again, a different conversation, and it would be almost unprecedented, but it seems plausible, especially in a situation that has seen so many of these crimes literally recorded for all to see. Thank you again.
Thank you for that, Mark. Since we're losing you, if I could ask the other panelists, I'll just give the questions that were directed to you so that we'll avoid not losing you. If you could, and since actually it's very connected to what you just said. So from Aideen Byrne, there's a question of considering arrest warrants and customary international criminal law and immunity. What are the dangers of low-lying fish rather than those higher up in the chain being brought before the court? So how does immunity law as well fit into the story. And the other one is, how does a court discern if a judicial system of a nation has been inactive? So isn't Netanyahu being charged in Israel with corruption and otherwise? And I'm so sorry to add one more question to this. If the court is to not issue arrest warrants, how could they justify that?
Okay, easy on the last one. They can't justify that. They can't justify that. This should have happened a long time ago. I think we can all agree on that. We might disagree on like the processes and what's led to this, but they can't justify that. The train is so far out of the station. This is one of the best documented scenes of atrocity. It's about time. It's past time. They can't justify that. On complementarity, very easy. Well, I mean, it's easy for me to say, so maybe it gets a little bit complicated, but the complementarity test is basically a two-stage test. Is the justice system, or is the state actively investigating the same person that the ICC would investigate or prosecute for the same conduct? And if they are, test two, is that investigation / prosecution genuine, right? Are they able and willing to do so genuinely? If you don't meet the very first test, the ICC can investigate and prosecute. So again, you can have the most sophisticated, robust, and independent judiciary in the world. But if that judiciary is not investigating, say, Benjamin Netanyahu, if the ICC issues warrants for starvation, if the Israeli judiciary is not investigating Benjamin Netanyahu for starvation, then it is inactive on that issue and the ICC can investigate. It doesn't have to be the same crime. So Benjamin Netanyahu wouldn't have to be prosecuted for starvation as a war crime or a crime against humanity, but he would have to be investigated for starvation as a domestic crime or something like that. It has to be the same conduct and the same person. And if that's not happening, then green flag for the ICC. And then finally, on warrants and low-lying fish and customary international law immunity, it's an interesting question. I mean, the low-lying fish or the mid-level perpetrators is more of a strategic question for the ICC. I would be interested to know what they're thinking there, but obviously don't know. It may be helpful for the ICC to strategically issue arrest warrants for those who have been reported, like senior level officials, as well as some mid-level commanders. Because if they can get some of those mid-level commanders to actually be surrendered to the ICC, perhaps through sealed arrest warrants, right? Because they're lower figures, then you can start engaging with them around, for example, a plea agreement where they plead guilty, but submit evidence of wrongdoing up the chain of command and share evidence of what they actually did and saw in Gaza and elsewhere, and build stronger, more robust cases for those very high-level officials on additional crimes. So I think that, but again, that's not as much of an evidentiary question for me right now as a strategic one, and I think a potentially strategically wise one. On immunities, I don't think even Israel believes that that on a legal basis, its own prime minister and defense minister are immune from international criminal law prosecutions. Its point is more that because it never joined the ICC has no jurisdiction, which, as we've seen in Ukraine and we see in Myanmar, is without any sort of validity. The ICC has territorial jurisdiction in Palestine and jurisdiction over any Israeli atrocities committed in the West Bank and Gaza. It's anything to the contrary is, again, just misinformation. So hopefully I answered those 3 questions. Thank you. Again, I have to drop out and I'm sorry, but thank you. It was wonderful to hear from you. I will listen to the rest of the recording because I'd love to hear the other panelists. It's wonderful to see you and fingers crossed for some good news from the ICC. Again, it's about time.
Thank you so much, Mark. I really appreciate it.
Thank you.
So the next questions up are for Huda, if I may. So I'm going to try to just couple a few questions for you. And since we have 15 minutes to go, there's a lot of questions for you, Abdelghani and Christina as well. So I'm going to just try to couple whatever I can catch. So I'll give these to Huda, and if later you guys want to also comment. First of all, one of the questions was in relation, says, thank you for your presentation. As you provided the context, I'd like to direct my question to you. I've heard from many Western scholars, lawyers, and investigators that evidence gathering is near impossible because we can't access Gaza. There's a clear dismissal of evidence gathered by Palestinians trapped in Gaza, sharing evidence. What do you make of this? In solidarity? And you have another question in relation to if whether on the memo there was a special focus on children in relation to genocidal intent. And generally, there were also questions on why just focus on on genocide, why not just also expand it to crimes against humanity and otherwise. If Huda, you could give us your insight on this, hopefully not too long before the time.
I'll try to be as short as possible. Thank you. So to answer the first question about gathering evidence, I don't think evidence on the ground is, we have evidence from the Israeli officials themselves of statements they've made regarding, starvation, the blockade itself, no aid entering, all of the cutting of water, cutting of electricity, all of these kind of do pose some form of evidence as to how evidence of the ongoing heinous atrocities. I would say a lot of what is happening, this creation of safe zones and then bombing them, all that kind of really, what kind of evidence are we looking for in this instance? If it's very obvious that the intent to commit genocide is there, it's very obvious that atrocities are happening. And again, who is not allowing investigations to happen? It is the perpetrator itself. So I think in that sense, the evidence is there. It's just we're choosing. There is a bias against actually seeing the evidence. With regards to the submission, our submission, while we don't necessarily focus on children with the intent of genocide, we do highlight how Israel, in its employment, for example, of the argument of human shields, it is basically identifying all Palestinians, regardless of whether they're males, females, adults, children. They're all identified as a target or as collateral damage, for a lack of a better word. So essentially, everyone in Gaza is targeted, not even every human, every rock, every tree, anything in Gaza, and everything is targeted. So that's the essence of our report. Our main focus is on the crime of genocide. We are trying to establish the intent for genocide, and we do employ other Israeli policies, illegal Israeli policies, such as ethnic cleansing, apartheid, domicide, ecocide, etc., to show, to prove, or to establish the intent. So this crime of genocide, I would say, ties up every illegal action ever committed, all the war crimes, all the everything that has been happening over the years, all of the discriminatory policies, etc. So I hope this answers the question. You're muted, Shahid.
Sorry. So there's one question, and I'm just going to follow up on what you were just saying. There's one question in relation to whether or not if a court decision would lead to reparations. And to just clarify, the International Criminal Court wouldn't be able to order reparations, but we're hoping to see that from the International Court of Justice, who is not able to order reparations per se, as in total in relation to the case of Palestine in the advisory opinion, but would advise on reparations. In the genocide case, it can order reparations. But I wanted to ask you, Huda, in relation to what you just said, the question also asks if people who supplied weapons would be held accountable. So did the submission speak also in relation to accountability for complicity in genocide, or are we looking something along that line?
From my memory, I do not recall this submission particularly addressing this matter, but I would assume in our subsequent submissions we will touch on these. We'll probably touch on these matters and the accountability of the rest of the countries, of the officials of other countries.
Thank you, Huda. So for the other questions, I have a bunch of questions for Abdelghani and Tristino. So what I'll do is I'll just read them out loud and then give you both some time to answer, since there's some overlap in the themes. First of all, is there, for Abdelghani specifically, in relation to the prioritization of cases, is there any precedent in relation to prioritization as per the availability of evidence? And then there's a question that's saying the crime which seems the easiest to prove is the illegal transfer by the occupying power of parts of its civilian population to the territory it occupies. There are Israeli government press releases saying that the cabinet has decided to expand illegal settlements. Arrest warrants for these government ministers seem easy to obtain. Isn't that where the office of the prosecutor should start? Not only as a matter of judicial economy, but also with an eye to take certain people out of circulation. In relation to, so Abdelghani, you spoke about generating a social alarm. And so doesn't this mean in this case that if the ICC pays mind to social movements, we know that there's a huge movement for Palestine around the world now, which has grown stronger in Western nations. Wouldn't this be a reason why there be potentially charges against Israeli officials? Lastly, there's a question. Another issue about the potential arrest warrants is that they would reinforce the narrative that the problem is Netanyahu and a few other extremist political leaders, thus denying the root cause of the problem, the occupation and the Zionist ideology. What's your take on this? So perhaps also further clarifying on this point that has already been brought up. So if both of you could, short positions on this. If Tristino, can we start with you?
Yes, although some of these questions were specifically addressed not to me, but so I will try to answer to some of them as usual very briefly. The transfer of civilians, we all know it's a war crime under the Rome Statute, but it's not only a war crime under the Rome Statute, it's also under investigation before the ICC. So when the former prosecutor Fadou Bensouda announced the completion of the preliminary investigation, she said that she had enough evidence to start a formal investigation into the transfer of civilians as a war crime. So transfer of civilians from the occupying power of territory to Palestine. What happened after that? It happened that since Karim Khan was appointed in June 2021, the investigation previously opened by the prosecutor was never constituted a priority for his office. What do we know actually is that he has never mentioned the scope of the investigation opened by the previous prosecutor, which covered not only settlements but also war crimes allegedly committed within the context of Protective Age 2014 and in the Great March of Return since March 2018. Since October 2023, the prosecutor undertook a number of actions in relation to the situation in Palestine. I mean, suddenly after the 7th of October, he realized that there was an open investigation in Palestine on his desk. And in different statements, and also in the op-ed he wrote for The Guardian, he mentioned settlers' violence potentially falling within the scope of the Rome Statute of his investigation. He said explicitly that he was opening an investigation in relation to settled violence. But if you look at all these statements, you will never find any mention, any specific references to settlements, to state policy, and to the fact that the transfer of civilians constitutes a war crime under the Rome Statute. I mean, for me, you get the idea that these violent settlers are like sort of lonely wolves who act on just their behalf without support of the state, without, acting in furtherance pursuant to a state policy. And this is very concerning because the impression that you get from these public statements is that the prosecutor is slowly working the investigation into the settlements, into transfer of civilians as war crimes into the oblivion. In other words, it's disappearing. And this is concerning for a number of reasons, also from an evidentiary perspective, because generally we hear that it's very difficult to investigate, to get access to evidence in Palestine. Nothing is more forced than it comes, in relation to transfer of civilians as war crimes. Most of the evidence is public. You can get it online, and also you can get the names of individuals allegedly responsible for these war crimes. So I think this is very important to emphasize. Then there was, I spoke more. There was another question, the last one you were mentioning, if you can briefly remind it to me. Okay, the risk of looking at specific individuals. Well, this is, of course, a problem for international criminal proceedings in general. But we don't have to place, too many expectations. The competence of international criminal tribunals is not to reconstruct the history, in this case, of the specific context since 1948. It's a very limited competence. And so it's a criminal tribunal, and it's called to establish whether or not individuals are criminally responsible. But at the same time, as I tried to stress before, and also in light of this question, it's for this that it's extremely important that the court, so the office of the prosecutor, first of all, focuses on the context, does not look at specific individual incidents, as isolated acts, so specific, for instance, military attacks in Gaza, just forgetting the context. The context is extremely important from an international law perspective, but also from an international criminal law perspective, because as I tried to say before, context means in particular crimes against humanity. When the investigation was opened in Palestine in 2014, one of the biggest flaws from my perspective and also from the perspective of the victims we represent was the lack of mention to crimes against humanity. I think that if this is going to happen again, this will be extremely problematic because it will try to look at the conduct of hostilities, forgetting the context, as I said before, in which these hostilities are taking place, and in violation of international, humanitarian law, but international law more in general.
Thank you for that. And indeed, the absence of contextualization has been a constant critique of international criminal law, at some points leading to absurdity in the perspective taken forward. Abdel Ghani, you have the last mic. I'm very sorry for the rest of the questions. We've tried to pick the ones that we're capable to expand on the most. So I'm very sorry for those that we weren't able to. And with regards to individual complaints to the ICC by human rights organizations, of Abdel Ghani can answer to that very quickly. And yeah, I'll leave the mic to you. We are running 1 minute, so if I could give you, if you could not be, I'm very sorry for the audience that we're running a few minutes over time.
I agree. I strongly agree with Tristino on many points, on everything actually, but I will come to that in the end. First, someone raised the question about reparations. The ICC can order reparations, and it did with Mahdi in Mali, in the case of destruction of cultural sites. It did order him to pay reparations. So the ICC can do that. But of course, it's very symbolic. The first question I wanted to address is the question of evidence and prioritization. Yes, the idea about lack of access to evidence and lack of cooperation is often used by the Office of Prosecutor to say, we cannot prioritize this because because we cannot access evidence and the state is not cooperating. The idea is that, as Tristino mentioned, there is a lot of evidence available on cases that do not require much evidence, and also, as Mark mentioned before he left, so conduct of hostilities, for example, might require evidence, but many other crimes, starvation, settlement activity, many others, don't require much evidence and can actually be concluded through an open source search online, simply. The idea of evidence also relates a lot to cultural biases, and that's why, for example, you have Judge Sebutende in the International Court of Justice. In her dissenting opinion, she wrote something horrific. She wrote that any destruction, this is really what she wrote, I quote, any destruction of evidence is not attributable to Israel's deliberate effort to destroy evidence, but it is the exigencies of the conflict with a group like Hamas that hides in the civilian infrastructure, etc., etc. So here there's culture. There's only culture and political bias. The idea that Hamas is a terrorist, immoral, illegitimate group that hides in the civilian area, and that Israel is a legitimate, civilized, liberal democracy that respects the law, and accordingly, any destruction, that's what she concluded amazingly, is not destruction, is not what you see. What you see is not what you see. That's the idea, really. So yes, evidence is a big issue. The Office of Prosecutor, as an office with massive biases, of course, evidence will play a big role, but the Office of Prosecutor needs to justify how it would not act in relation to crimes that do not require much evidence. The third point, when it comes to social alarm as a factor that determines prioritization and selection of cases and situations, this factor was already the pre-trial chamber criticized this criterion maybe in 2009. I can't remember in which case, but already 15 years ago. That's what I'm saying. The idea is that the Office of Prosecutor has developed many criteria in its attempts to commit to its biases against Global South peoples, and its practice and policy have nothing to do with coherency or consistency. However, still, everything the Office of Prosecutor did, whatever it committed to and whatever it didn't commit to, still points to prioritizing cases against Israel. So if we stick to social alarm, prioritize cases against Israel. If we stick to numbers and quantitative factors, stick to crimes against prioritization of cases against Israeli officials. If you stick to qualitative factors regarding nature of crimes, manner of commission, today we have TikTok videos of an Israeli soldier firing a tank shell at a tent, and proudly, you know. So this is the idea of manner of commission of the crime. Having, you know, you have the Telegram channel where you have people with dead bodies being being run over by tanks, etc. This is all something that makes up the analysis of qualitative factors, because manner of commission of the crime here is very atrocious. So really, prioritizing cases against Israel is something that the office cannot escape. I need to conclude with 2 points together, and they relate to what Tristino just mentioned, which is settlement activity, settler crimes, and the last question, which is about that addressing Netanyahu's crime does not address the real issue, etc. They're all the same point to me. So the Office of Prosecutor, clearly, as Tristino mentioned, never tried to investigate crimes against humanity in the West Bank and Jerusalem. And this caused a lot of anger in Palestinian circles and in circles of international lawyers. also, the Office of Prosecutor never mentioned, never tried to investigate properly settlement activity in the West Bank and Jerusalem, which doesn't really require a lot of evidence, as Tristina mentioned. Instead of that, and this is my last point, the Office of the Prosecutor is now interested in prosecuting settler crimes. Crimes by settler groups. This again takes us back to the idea of the biases of the Office of the Prosecutor. The Office of the Prosecutor would want to prosecute settler groups to basically tell us, yeah, it's an aberration. It's a problem, it's a sporadic crime committed by non-state actors in Israel. But the Israeli state is fine, it's good. It's just a group of settlers that will need to be prosecuted. And that's why when we see news coming out of the US about punishments, sanctions against settler groups, this is ridiculous. It's the same idea that, there is a bias against non-state actors, and they're the only ones who commit crimes, but state doesn't commit crimes. So prosecuting settler groups is the same idea that, yeah, it's an aberration, what's happening. It's not the Israeli state, it's some settler groups. I think it is much better, back to the other question, which is about addressing the root causes and not just prosecuting Netanyahu. It's much better to prosecute state actors and making sure that these are crimes of the state, they're not an aberration, rather than prosecuting settler groups. The court cannot address the whole issue, but at least the court can address crimes of the state. The problem that we have is that the court, the also prosecutor, will try to address non-state actors, and even if it tries to prosecute state actors, it will always try to frame it as an aberration. And that's why the office, for example, is interested in war crimes, because war crimes can be committed as single acts by individuals without necessarily involving any state policy or plan. Whereas crimes against humanity and genocide are crimes of the state. But the office is always trying to avoid talking about crimes against humanity or genocide for that particular reason. It's the idea that it's an aberration. Even if the office addresses conduct of hostilities, it will always probably address a disproportionate attack, not willful killing, a disproportionate attack by a pilot who made a mistake, or an officer who intended to kill someone, but it's just an officer. It will never address the entirety of Operation Protective Edge in 2014, for example, as a campaign directed against the civilian population. It's the idea, it takes us back again to the bias for the state, that any mistakes that the liberal civilized state does is probably an aberration. It's not the state.
Thank you for that, Abdelghani. On that note, so we've come to the end, and as we end, one thing must be said. We've been talking a lot about the technicalities of the court, but we tend to forget that those who speak of international law are at a place of privilege and capacity to affect reality. One of the questions that was posed was in relation to whether or not acting in relation to an ongoing conflict is usual. And of course it is. One of the points of international criminal law is not just to react, but also to facilitate deterrence. What has already happened is already an atrocity, and we looked at 7 months of unimaginable horror. What we stand here today is that the people in Gaza are looking towards these arrest warrants with hope that the narrative might change, and that hope resides with people with the privilege and capacity to do so. What we are trying to communicate here, that regardless of these very indeterminate technicalities, the reality of which we speak is dire, and action must happen. This action must trigger a larger reflection in the field of international criminal law. This is not just only the beacon of hope for people in Palestine, but is also Palestine saving the international legal system towards falling outside of relevance to the reality of which it lives. Because as it stands now, it is very far away and it has suspended reality. Thank you very much for those who have stayed with us, and for those who have tolerated the 10 minutes extra. We apologize for that. Thank you for your interest, and please stay tuned to Law for Palestine's events. We all hope to see the better. And of course, our prayers, our thoughts with everyone in Gaza. Have a good evening, everyone, and good night.
Thank you. Have a good night.
Thank you. Thank you, Shad.
Thank you.
Thank you, Terestina. Thank you, Hala.